on the subject parcel. Appellant concerns have been received from California Native Plant Society, and there are two co-appellants, which are Environmental Commons and Friends of the Wallala River. The main concerns listed by CNPS are plant-related concerns, including reestablishment of native plants, weed issues, rare plant concern, a wetland concern, and a plant community concern. Other concerns are compliance with the California Environmental Quality Act and impacts to the Wallala Bluff Trail. In regards to that, I just wanted to state that the GeoWeb material, I believe, is designed for plant reestablishment. There is a long-term restoration plan as part of the project, and that rare plant, wetland, and community issues are clarified by Kim Fitz in a letter that is in your board packets. Regarding the CEQA compliance, CNPS is concerned that the project is piecemealing. I wanted just to state briefly that this project is a standalone project and that it warrants the proposed development in and of itself, regardless of any future or nearby related projects, and that the overall impact would be beneficial as opposed to the no project alternative, which would result in detrimental impacts to the environment. I guess that's it for now.
Okay. Just at the November 19th hearing, where I was the permit administrator for that, there were 7 people that spoke in opposition to the project. There was 1 person that spoke in favor of, and then obviously the applicant speaking in favor of the project. These same issues were in front of me at that time. At that time, it was a standard retaining wall. That's since been changed to a GeoWeb design. There was some concern raised that the owners, this was a way for the owners to relieve themselves of having a trail at that site, that people would not be able to use the trail for an extended period of time. I did give some consideration to requiring compensation from the property owner to the land trust for a temporary loss of the use of that trail, but I didn't feel like there was any consensus to move down that path, and so I did not require that. I did add special condition number 8, however, that states that as expeditiously as possible, the applicant shall return the existing coastal trail within the easement area on the subject parcel to its currently existing status and condition. The intent of this condition is to include the county as a responsible party together with the Redwood Coast Land Conservancy to enforce the requirement that the replacement and reconstruction of the trail occur as soon as possible. What I wanted to do was make sure that that the county lends its support to seeing this be returned to a trail, a permanent trail, as quickly as possible. Lastly, what I'll say is that the project before you with the GeoWeb is an environmentally superior project to that which I approved in November.
I just wanted to add that the project that was approved at the November 19th hearing was a concrete block retaining wall. At that time, it was the least impacting option that was known to be available. Since that time, the alternative material GeoWeb was found to work. That material would result in less ground disturbance and less visual impacts. The materials, there's information located in the board packets, both from myself and I believe from Julie Price of Round Associates. The material describes how the alternative differs from the approved projects, and there's also a modification to the CEQA analysis that was included.
Thank you. Any additional from the staff?
No.
Okay. Any questions at this point to the staff? Supervisor Delbar.
Thank you, Mr. Chairman. Mr. Hall, special condition number 8, which page is that on? 'Cause I don't have a special condition number 8 in the staff report.
Well, it was an addendum to the staff report, or excuse me, a memo included.
Dated November 19th.
It's dated November 19th, and I'm trying to track it down here. And unfortunately, these aren't listed in order, but it's probably 2/3 of the way back. There's a memorandum to the Coastal Permit Administrator from Teresa Badeau recapping the November 19th meeting.
Okay, 2/3 of the way through this stack?
This stack. It was the staff's presentation. You may have some additional materials that were provided by the applicant and by others. If you see in Appendix B, it's immediately before Appendix B. It's given a page number 1, but it's obviously not the first in order.
I found it.
Okay.
Okay. That was about a quarter of the way through that stack. The special condition number 2 requires a 50-foot buffer. Do you have a map or a picture that will show me where that 50-foot buffer is? I didn't see that delineated anywhere specifically.
I don't recall seeing one. Do you?
I don't believe that it's delineated. I can check the survey report.
I think we'll have to get back to you on that.
Okay,
Teresa can look it up.
that's fine. Thank you. Thank you, Mr. Chair.
Okay, other questions to staff at this point from the board? Okay. Hearing and seeing no one rush forward, we'll move to a presentation by the appellant. This will be 20 minutes maximum. There are multiple appellants. You must divide your time between those 20 minutes, and followed by the applicant for 20 minutes. The clerk will time the presentation. We have a timer there at the podium, green, yellow, and red lights. Red light will mean the end of the 20-minute period. So we'll proceed with the appellant's presentation of 20 minutes.
Good afternoon, Supervisors. My name is Britt Bailey. I'm Director of Environmental Commons, a nonprofit organization based in Gualala. I appreciate your attention and your consideration regarding this proposed project, as well as our appeal for denial. We're seeking denial of this CDP for a few very fundamental reasons. First of all, it does not comply with the California Environmental Quality Act. It is but one part of a whole redevelopment project which has been significantly segmented into a multitude of permit applications. This piecemealing is not allowed under CEQA. CEQA requires that the entire project be reviewed under one application so the agency as well as the community can formally consider cumulative environmental impacts as well as alternatives. Secondly, the project does not comply with the Mendocino County Local Coastal Program. By segmenting this project into various permit applications, the applicant has been able to dodge the LCP, specifically the Gualala Town Plan policy, which prohibits retaining walls when new development is constructed on blufftop parcels. If this project in its entirety were submitted in one application as required by CEQA, the retaining wall in question would not be allowed. The planning staff and the planning agent are well aware of this. More broadly, the local coastal program does not permit retaining walls unless deemed necessary to protect existing development. We contend that the retaining wall is not necessary as feasible and available alternatives exist, and we question whether an informal dirt parking lot that was not included in original permits should be considered existing development. Instead of seeking a less environmentally damaging alternative, the applicant is proposing